What happens when a man facing 80 years in prison for dealing meth gets offered a lifeline that could set him free or send him away for decades? Today, we're diving into a high-stakes guilty plea where one wrong move could mean the difference between freedom and a lifetime behind bars. Larry Robert Valance, too, is about to make the most important decision of his life, entering a recovery court program that the judge warns will control everything about his existence for the next 2 years. But here's the kicker. Only half of the people who enter this program make it out. The other half, they go straight to prison. Buckle up, because this courtroom drama is about to get real.
Mr. Valance, would you please stand and raise your right hand for me? You solemnly swear that the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
I do, Your Honor.
Put your hand down. Are you Lyle Robert Valance III?
Yes.
Sit down.
Okay.
Mr. Valance, a guilty plea hearing is an important event. It includes the waiver of constitutional rights that you have, so listen carefully. If you have a question, ask me. If you need more time to talk to Mr. Wirgo, you just say so, okay? Now, you're entering a plea here into the recovery court program. I'm sure Mr. Wirgo has explained some of that to you. That means we're going to be really involved in your life for 2 years, and you're going to have to make a lot of changes. Well, really, you only have to change one thing, everything. And if you're not completely committed to being serious about it and doing it for your own good, not to stay out of trouble, then I'm going to tell you, entering this plea today would be a grave mistake.
Hold up. Did this judge just say he needs to change everything? This is where it gets intense. Folks, recovery courts aren't your typical probation. They're intensive supervision programs that literally control every aspect of your life. We're talking mandatory drug tests, counseling sessions, court appearances every single week, curfews, employment requirements, and zero tolerance for slip-ups. The judge is being brutally honest here. This isn't a get-out-of-jail-free card. It's a grueling 2-year marathon where one failed drug test, one misappointment, or one bad decision sends you straight to prison for those 40-year sentences. What would you do in his shoes? Take the gamble on changing your entire life, or roll the dice with a trial? Let me know in the comments what path you'd choose.
Grave mistake. If you're hedging anything in your mind about just trying to avoid trouble now or see what you can get away with, this is a terrible plea because you're going to plead guilty to B-grade felonies with drug doubles. If you don't graduate the program, you're going to go to prison for a long time. About half of the people in the program graduate. The half that do are the ones that are serious, and they're doing it because they want to do it. If that's you, this is a great program for you. If that's not you, nobody's going to be mad at you. You don't have to do this today, and Mr. Wirgo can come up with a different plan for you. You understand that?
I hear you, Your Honor. Sorry.
So I have to advise you the maximum penalty that you could face for these charges. Under this plea, you'd be pleading guilty to count 1, delivery of methamphetamine with a second or subsequent offense notice, commonly known as a drug double. That means that it's a felony punishable by a maximum of 40 years in prison and or a $50,000 fine. Count 2 is again delivery of methamphetamine with the drug double. It's again a felony punishable by a maximum of 40 years in prison and or a $50,000 fine. Do you understand the maximum penalty that you could face?
I do, Your Honor.
Let's break down these numbers because they're absolutely staggering. 2 count of delivery of methamphetamine, each carrying 40 years maximum. That's potentially 80 years in prison and $100,000 in fines. For context, that's more time than most murderers get. The drug double enhancement the judge mentioned means this isn't his first rodeo with drug charges. It literally doubles the maximum sentence from 20 to 40 years per count. Now here's what's fascinating from a legal perspective. By pleading guilty to these enhanced charges, he's essentially putting a loaded gun to his own head. If he fails the program, the judge doesn't have to give him the minimum. He could theoretically impose the full 80 years. That's the ultimate high-risk, high-reward scenario. The prosecution has him dead to rights, so this recovery court might be his only shot at avoiding decades behind bars.
Your Honor.
Are you on probation or parole anywhere?
Probation, Mr. William.
In district court or here or to me?
You, I believe.
Okay.
Jim Fagan.
Okay. And do we have a pending violation on that or?
No, because these offenses, I believe, occurred.
They occurred before. Okay, so then we'll just amend that probationary order
Right.
to, Okay, gotcha. All right, so this won't affect that probation. We'll just amend that probation to be wrapped into your recovery court. Okay,
Okay, thank you, Your Honor.
all right. Now, did you read and understand the rights listed on the advice of rights form?
Yes,
And you signed that form today?
I did, yes.
Do you have any question for me about any of those rights?
I do not.
Do you understand that if you plead guilty, you give up all those rights?
I do.
Is that what you wish to do today?
I do.
If I accept your plea, you can't come back later and tell me that, gee, it wasn't my own free choice to enter the plea for any reason at all, including promises made beyond the plea agreement or any threats made to you or anything at all. Do you understand that?
I do.
Also, when you plead guilty, you lose the right to appeal. And if you wanted to appeal to a higher court, you'd have to seek permission by filing an application. And the types of issues that you could raise on appeal are very limited, much more limited than if you were convicted after a trial. Do you understand that?
I do.
Now, the plea agreement provides in exchange for your plea to those charges, the prosecutor will dismiss the habitual second notice, which they kind of have to do. They have to pick the drug double or the habitual second. Understand that. You can't stick with them both. But so they're choosing the drug double and dismissing the habitual second. And there's a sentence agreement for the Sheboygan County Recovery Court Program. Do you understand the terms of that plea agreement?
I do, Your Honor.
Mr. Virgo, is that a full, fair, and accurate statement of its terms?
It is, Your Honor.
Ms. Goodrich?
Yes.
Mr. Valens, I'm not bound by that sentence agreement. If at sentencing I don't want to follow it, I don't have to. Now, the whole recovery court team has talked about you and your case and thought that you meet the requirements of the program. So if you enter this plea today, I'll be amending your bond to have you begin participating now, and that'll count toward your graduation date, be sort of a head start. But the final decision whether to continue in that program is mine at the sentencing. And if something's happened where I don't think that's a good fit, I don't have to continue. But if I don't follow that sentence agreement, you would be allowed to withdraw your plea if you wish. Do you understand that?
I do.
There's an important exception to that. If you were to violate your bond, not show up for court, abscond on your bond, or commit new crimes, then I wouldn't have to follow that plea agreement, but you would have lost your right to withdraw your plea by your own misconduct. Do you understand that?
I do, Your Honor.
Other than the plea agreement, has anybody promised you anything in exchange for your plea?
No,
Has anybody threatened you?
No.
Is it your own free choice to enter that plea?
it is.
Knowing all this, how do you wish to plead to the charge in count one, delivery of methamphetamine with a drug double notification?
Guilty, Your Honor.
How do you wish to plead to the charge in count two, delivery of methamphetamine, again with a drug double notification?
Guilty, Your Honor.
And there it is. Guilty, Your Honor. Those three words just changed everything. But notice what the judge just laid out. This plea agreement isn't set in stone. The judge explicitly stated she's not bound by it and can reject it at sentencing. Plus, there's a massive catch, 22 here. If Valen screws up even once before sentencing, Mrs. Court fails a drug test, gets arrested, the judge can throw out the plea agreement, but he's still stuck with his guilty plea. That means he could end up with the worst of both worlds, a guilty verdict and no recovery court program. It's like signing a contract where the other party can change the terms, but you can't back out. From a legal strategy standpoint, this is incredibly risky. His attorney is banking everything on Valence's ability to stay clean and compliant starting right now.
Your Honor.
Mr. Virgo, would you assist with the factual case?
Yes. Mr. Valens, do you recall a couple of incidents that happened in July of last year?
Yes.
Okay. And on or about July 18th of last year, did you make an arrangement to sell somebody some methamphetamine?
Yes.
And that happened, you met with them at a convenience store here in Sheboygan, is that correct?
Yes.
Okay, and did you give them methamphetamine in exchange for money?
Yes.
And did you have any legal rights to have or to sell that methamphetamine?
No.
Okay, and then again on the 21st of July of last year, you made a similar arrangement, correct?
Yes.
And you met with an individual then at a convenience store, correct?
Yes.
Or excuse me, a dollar store on the second,
Yeah.
correct? And you once again arranged to sell methamphetamine to this individual?
Yes.
And you did possess the methamphetamine and sell it?
Yes.
And once again, that sale occurred here in the city of Sheboygan?
It did.
And you agreed that the city of Sheboygan is in Sheboygan County?
Yes.
Your Honor, I believe that satisfies all the elements.
This
Okay, yes,
factual basis is textbook drug dealing admission. 2 separate sales, 3 days apart, both at public locations, a convenience store and a dollar store. What's telling here is how straightforward these admissions are. No hesitation. No, I don't recall. Just yes after yes. This suggests the prosecution probably had him on surveillance, possibly with controlled buys using informants or undercover officers. Meeting at public places in broad daylight shows either boldness or desperation. From a criminal law perspective, each element of the crime is being methodically established. The substance, meth, the exchange, drugs for money, the intent, arranged meetings, and jurisdiction, Shiawassee County. These aren't possession charges where he could claim personal use. These are straight-up distribution charges with him admitting to being a dealer.
Okay, yes, and at the time you had a conviction. Oh, no, wait a minute, Miss Goodrich, the drug double indicates that the conviction was on 8/8/2023, which postdates the offense dates.
Oh, so that, be valid then, so,
You want me to indicate dismiss habitual and drug double?
yes, thank you.
All right, so Mr. Valance, what that means is that drug double notification I talked about doesn't apply. So instead of 2 felonies of 40 years maximum, they're 20 years maximum. Okay.
Whoa. Plot twist. The prosecutor just made a huge error that cut Valance's potential sentence in half. The drug double enhancement requires a prior conviction before the current offense dates. But his prior conviction was in August 2023, after these July 2023 drug deals. That's a massive prosecutorial oversight that just saved him 40 years of exposure. Instead of facing 80 years max, he's now looking at 40 years total. This is exactly why details matter in criminal law. One date, one technicality, and boom, half your potential prison time vanishes. You can bet his defense attorney was holding his breath hoping nobody would catch this until after the plea was accepted. The judge caught it, showing she's thoroughly reviewing the case. This kind of mistake could have been grounds for appeal if discovered later.
Okay. Obviously that doesn't change your mind, does it?
No, not at all.
Okay. All right. Are you satisfied with that factual basis?
Yes, thank you.
Mr. Wergo, are you aware of any other premises to extra inducements?
None, Your Honor.
No, Your Honor.
And Mr. Wergo, in your judgment, has the court complied with CR 6.302?
It has, Your Honor.
Yes,
Mr. Valance, I gave you quite a lot to think about with whether you want to enter this plea and enter a recovery court program. Are you sure that's what you want to do?
Yes, Your Honor, I would like to do that.
All right. Any objection, Mr. Wergo, to amending his bond conditions to having begin the review sessions?
No, we discussed that and we figured it was happening, Your Honor.
All right, so Mr. Valance, what that means is we'll have you begin the recovery court process, and you'll come for the weekly review hearings with the whole team here in the courtroom. Mr. Wergo will not be there. We do have a defense attorney on the team, but he's not your lawyer. So if there's anything between now and the sentencing that's happening in that review that you don't feel comfortable with, you just say so, and we'll pull the plug on it and let you talk to Mr. Wergo before we go forward. Okay, you understand that?
I do.
All right. All right, well, I do find that your plea is knowingly, understandingly, and voluntarily made, and that there is a sufficient basis in fact and law to believe that you're guilty of the 2 deliveries of methamphetamine. So I will hereby accept your plea. We'll schedule sentencing a bit out, Agent Fagan, to August 27 at 10:30 in the morning. But Mr. Valance, I'm going to amend your bond conditions to have it be recovery court conditions. So you'll stop by and see Nicole once you're done here, if she's available. And then we'll see you tomorrow morning. The men come in at 9:30 every Wednesday morning for review. Do you need to talk to you for a minute or no?
No, because I can see it now.
Okay. All right, any questions for me, Mr. Valance?
No, none, Your Honor.
Okay, we'll see you tomorrow.
Thank you.
And just like that, the countdown begins. Tomorrow morning at 9:30 a.m., Valance starts his 2-year journey that will determine whether he walks free or spends decades in prison. The judge's final words, "See you tomorrow," carry enormous weight. Missing even that first meeting could trigger a bond violation and destroy his entire plea deal. Notice how the judge mentioned his attorney won't be at these weekly sessions? That's unusual and concerning. He'll be navigating this complex program largely on his own. The fact that sentencing is set for August 27th gives him about a month to prove he's serious about recovery. Every single day between now and then is a test. So let's recap this incredible case. Larry Valance just pled guilty to 2 counts of methamphetamine distribution, originally facing 80 years in prison before a prosecutorial error cut it to 40 years maximum. He's gambling everything on a recovery court program with a 50% failure rate, where one slip-up sends him to prison for decades. The judge gave him every opportunity to back out, warning him that he needs to change everything about his life. He's already on probation, making this an even higher tightrope to walk. Starting tomorrow, he'll report to court every week for the next 2 years, with a judge watching his every move. This case perfectly illustrates the harsh reality of drug crime sentencing and the extreme measures some defendants will take for a second chance at freedom. Will Valance be in the 50% who graduate or the 50% who go to prison? Only time will tell. If you found this case as intense as we did, smash that like button. Drop your thoughts in the comments. Do you think he'll make it to the program? And don't forget to subscribe and hit the notification bell for more jaw-dropping courtroom breakdowns. What case should we cover next? Let me know below.